Over the last couple of years, you may have heard about GDPR, the European Union's General Data and Privacy Regulation. But do you know what CCPA is? Hi, I'm Tony Anscombe, a security evangelist at ESET. Firstly, let's explain the acronym CCPA. It stands for the California Consumer Privacy Act 2018. Both GDPR and CCPA aim to guarantee the protection for individuals regarding their personal data, and they apply to companies and organizations that collect, use, or share consumer data. CCPA is due to take effect on January 1st, 2020, and is likely to have a global impact, just as GDPR did when it took effect in May 2018. There are some differences, one of which is the requirement under CCPA for organisations to provide consumers with the ability to look back at their data over the last 12 months. So what are the other main differences? Well, the focus for CCPA is on transparency and limiting the ability for organisations to sell or share personal information unless they have consent. So you should expect to see the term "do not sell my personal information" as a link on the homepage of websites. The transparency is extended when companies merge or acquire other businesses and will provide consumers the right to opt out if it's believed that the combined organisation used the data in an inconsistent way in which the consent was granted by the consumer. CCPA does not require the appointment of a data protection officer, the maintenance of a data register for processing activities, or the need for impact assessments. It also excludes some categories of personal information, such as medical data, that is covered under other US federal laws, such as HIPAA. There is one other limitation to CCPA when compared to GDPR. The latter applies to all individuals located in the EU, even if temporarily, such as tourists, whereas CCPA really only applies to Californian residents, regardless of where they are at the moment the data is potentially collected. There are, of course, several other differences, but there is one similarity that we as consumers should all celebrate: the right to be forgotten. Having legislation in place that empowers a consumer to insist that a company removes any data it holds on them gives control back to the person the data is about. CCPA applies to any business in California with either a gross revenue in excess of $25 million, trades personal data of more than 50,000 consumers, or makes 50% of its revenue from selling consumers' personal information. Again, there are unprecedented amounts of data being collected about every aspect: business, personal, environment, just to name a few. Any privacy legislation that limits a company's ability to collect data without good reason or without explicit consent is a step in the right direction. Let's hope that the US federal government raises the bar on privacy and follows California's example. For more business tips and tricks, check out the business section of the ESET corporate blog and the data protection resources available on our website.